What we're going to talk about today is a very common and very misunderstood area. We call it elder law, okay? And elder law consists of many things, but I try to group it into sort of categories. And there's three major categories that I'm going to talk about today. And there are three major categories that people lump together that are really separate areas. And in addressing those categories, I can probably address many of your concerns. This is not intended to be a running monologue. If you have a question, I'm happy to answer it. If it's relevant for the group, I'll probably address it fully. If it's more of a personal thing, I'll be available after the session for any questions or concerns. All right. Those three areas are probate, got to avoid probate, estate taxes, and nursing home stuff. All right? And somehow people have jumbled together in their head, I got to avoid probate. If I avoid probate, I'll avoid estate taxes. If I avoid estate taxes and probate, I'll avoid nursing home costs. And what I'm here to tell you today, that they're really three different things, have a little effect on each other, but three different things. So people come into me and they go, hey, I got to avoid probate. I got to avoid probate. I said, oh, really? Okay. So I go, what's probate? So I don't know. I just got to avoid it. So I throw it out to the audience. What is probate? Anybody have a succinct answer?
Courts.
Courts? Okay, that's an element. Anything else?
Wills.
Wills? That's often an element, but not necessarily. Anything else?
Time.
Assets.
Time.
Time? Okay, well. Creditors, adjudication. Okay, if you take nothing away but this today, in 25 words or less, this is what probate is. Probate is anything that you die with in your name alone has to get to somebody or something through a process. That process is probate. It's not a question of whether you have a will or don't have a will. And I hate to tell people that. I say, well, I don't need a will. It's not the question at all. It's whether an asset is in your name alone or not in your name alone. If it's in your name alone and you want it to get to somebody, your children, your family, your organization, your charity, it has to go through probate. If you have a will, it'll go through the court process by the will. Once the will is accepted, once the executor, now known as a personal representative, is nominated or accepted, then you can distribute per the terms of the will. If you don't have a will, but you have an asset in your name alone, it's a state distribution known as an intestate distribution. Usually next to kin kind of thing. So hopefully if you don't have a will, you like your next to kin. All right, so that's what probate is. Now in actuality, your assets, many, if not most of them, pass in methods other than probate because they're not in your name alone. So what are some other methods? There's really three other methods that assets pass. Anybody want to venture to guess how an asset may pass other than probate? All right, beneficiary, trust.
Joint ownership.
All right, we got all three very quickly. All right, so I'll address each of those separately. All right, if you have a joint account with somebody, a spouse, a child, if you die, that asset doesn't go to probate. It's not in your name alone. It passes to the other joint owner. All right? I always give one caveat when I talk about that. If you have a joint account with a spouse, you sort of have some protection. Each of you sort of protects each other from each other's creditors unless it's a joint creditor. So pretty safe to have a joint account with a spouse. If you have a joint account with a child or children, just tread with a little bit of caution. Because if it's a joint account, it means it's a current asset of each joint owner. So if that child has creditors, or God forbid that child is malfeasant, is that a word? You could lose that money. So that's the only caution that I have on joint accounts. Now, in our third method, which is named beneficiaries, that's how I would advise having an account with a child. But basically, when you have an account with a named beneficiary, and the most common ones are life insurance and IRA 401 type K. When you die, that account doesn't go through probate. it goes to the named beneficiary on the card that you filled out. All right? Now, once again, I have another caution on that for you. People fill out beneficiary cards on life insurance and on IRAs maybe 30, 40, 50 years before. All right? So 30 years before, your spouse may be your beneficiary. But guess what? Your spouse is no longer with us. Guess what happens? Goes through probate. Got no beneficiary because your beneficiary isn't living. Or God forbid, your son was your beneficiary you haven't talked to in 30 years. Guess who's going to get that asset? Your son who you haven't talked to in 30 years. Okay, and I've seen quite a few of these things, actually. So what I urge people to do on, in particular, those types of accounts, life insurance, IRAs, anything with a named beneficiaries, is to make sure to review those beneficiaries every 3 to 5 years to make sure, number one, they're still with us, and number two, that's the person or the people that you want. Otherwise, you could have a bad result. Now, in terms of bank accounts, and I said why I don't think it's a great idea to have your kids on as a joint owner. Well, I'm afraid to touch that area, I might blow up. A better way to have a bank account with a child is what's called a TOD or a POD account, which means transfer on death and payable upon death. What that means is the child is not a current owner. So if the child has a problem, it's not going to affect them. It's only his or her future asset, and you're safe from the child's malfeasance. All right? They can't get the asset because they're not the current owner. So my suggestion is if you do have a bank account with a child, that you're much better off with a TOD or a POD account. And people say, well, I got my kid on there, so he or she can write checks for me if I can't. And if he's on there as a beneficiary, he can't. That's true. But that situation is very easily defeated by something that we'll talk about a little bit further in the program. If you have something called a durable power of attorney, which gives that child the ability to act for you financially if you can't act for yourself, then even as a beneficiary, they can access the account and write checks for you. Okay? The third way that assets pass is by trusts. All right? Why do they pass by trusts? Once again, what is probate? Anything that you die with in your name alone. If you have real estate, for example, and you deed it to the trust, I, John Smith, deed it to the John Smith Trust, and that's recorded at the Registry of Deeds, guess what? When you die, it's not in your name alone, it's in the name of the trust. Your trustee goes, they take title, you can sell the property. All right? But in order for a trust to actually work to avoid probate, you got to what's called fund the trust. All right? A lot of times people go to lawyers and they say, oh, a trust, well, a trust is this all-purpose thing. I think the trusts are very useful for certain situations. I think they tend to be oversold as magic bullets, and they give people a false, what's the word I'm thinking of? False sense of security when it's not the case. In order for something to avoid probate, if it's in a trust, for example, if it's a bank account, you literally have to put it in the trust. You get a card from the bank that says, all right, right now I, John, am the owner. You fill out the card. Now the John Smith Trust is the owner. You give a copy to the bank. And then when you die, bank's got a copy. It says, okay, the three beneficiaries are Joe, Jill, and Sam. And they give the money to Joe, Jill, and Sam. With real estate, to put it in the trust, once again, you have to record a deed that deeds it to the trust. So another way of avoiding probate. All right? But if you take nothing away from here, probate is anything that you die with in your name alone has to go through a court process. If you have a will, passes by the term of a will. If you don't have a will, intestate distribution. I'm going to move on from probate to estate taxes unless anybody has any pressing questions.
When you talk about trust, can you explain revocable versus irrevocable?
Yeah, I'm actually going to get to that in a little bit. Okay? Don't mean to put you off, but we're going to get to the differences between revocable, which is helpful for avoiding probate, and estate tax purposes, which I'm going to talk about next, and irrevocable, which is helpful for nursing home purposes, and also avoidance of probate. Okay? So the next thing I'm going to talk about is estate taxes. And people, I think, dwell too much on estate taxes. It doesn't apply to 90% of people, although with the value of real estate here in eastern Massachusetts, it probably applies to a lot more people than it otherwise would have. Here's the thing you need to know about estate taxes. If your estate, meaning everything that you have, real estate, IRAs, bank accounts, life insurance, probate, if your estate or your estate with your spouse is less than $1 million, don't think about estate taxes again. It's not going to apply to you. And that's the state estate taxes. The federal estate tax threshold is $5 million. May come down at some point, depends on whether probably have a Democratic or Republican administration. The state's been $1 million for a long time, and it's likely to remain $1 million. All right? So once again, if it's under $1 million, don't think about it again. If it's over $1 million, there are some things that you can do as a spousal couple to let you leave $2 million, but that doesn't happen automatically. What tends to happen is two spouses either own things jointly or they're the named beneficiaries of each other. So when the first spouse dies, guess what? Everything goes to the second spouse. So say you have a spousal couple with the totality of what they have at $1.7 million. All right, first spouse dies, second spouse is the joint owner, the named beneficiary. Everything goes to the second spouse. When the second spouse dies, that spouse is allowed to leave $1 million. But guess what? He or she is dying with 1.7. The amount that's over $1 million, which in this case is $700,000, is subject to estate tax. And the estate taxes can be pretty onerous, up to 16% or so. It's a lot of money. All right? Now, had they done this a little bit differently, and it's usually done with trusts, either with real estate or bank accounts, that they were able to fund the living trust of the first deceasing spouse with the excess amount over $1 million, say it was real estate, and they put the value of the real estate into the first deceasing spouse's trust, which doesn't need to be done until the time of death, that $500,000 for the house automatically goes to the first deceasing spouse. So when the second one dies, the most he or she could have is $1.2 million, is taxed on $200,000 instead of $700,000. So once again, that's generally done by living trusts, and the living trusts have to be funded with either real estate or bank accounts or accounts of any sort. By the way, living trusts and IRAs are bad mixes, 401ks. So I advise people, if you have IRAs or 401ks, you can't really put them in the living, you can't really retitle them in the living trust, but your living trust should not be the beneficiary of those items either. Okay, so living trusts, helpful for avoiding probate, because the asset's in the name of your trust, not in the name of your, not in your own name, and helpful for estate tax purposes if you have a taxable estate. The only other thing that I'm going to say on estate taxes, and there's a lot of confusion about this $10,000 a year gift, which is actually $14,000 a year. All right. If your estate, yourself with your spouse, is under $1 million, there's absolutely no logical reason to make that gift, it can make your kids angry, I don't know, of $14,000 per year. All right. What the $14,000 a year has to do with, if your estate is over $1 million, and say it's 1.1 million, so we'll make it easy. All right. You can gift as many individuals in one calendar year up to $14,000 to sort of knock your asset level down to $1 million without the cap being lowered. So say you have 3 kids, $14,000 is $42,000. Year number 1, you give out $42,000, you're at 1.1. Year number 2, 42. Year number 3, 42. At the end of 3 years, and I understand there's stuff coming in and whatever, you're down below $1 million and you've achieved your goal. All right, so that's the purpose.